We're recording.
We're in it. They're recording it.
It's too small.
Recording in progress. Recording
We're just going to need to mute everybody.
This California law allows you to establish a trust for your pet.
Will you turn it off, please? I'm in a meeting.
Is the grandchild of Randy Volpel of Santee. Yeah, the shooter in Colorado Springs, the grandson of Assemblyman Randy.
You know, this isn't like it's not easy to do.
Hello, everybody. Good evening. I'm going to ask our host to please mute everyone on the call if possible. So there we go. Thank you. Thank you so much. It makes it a lot easier. Good evening. Buenas tardes. My name is Patricia Perez, and I am AARP California's State President Emeritus. On behalf of AARP California, it is my pleasure to welcome you to our monthly financial series, Let's Talk Dinero. We know that thinking about your financial future can be overwhelming, like budgeting and getting out of debt, which, by the way, we've covered these subjects here in the past, and we have videos you can watch, so make sure you visit us again. We also don't know that it's not easy thinking about what happens to our assets after we're gone. Some of us keep procrastinating, and we often think, hey, I'll be dead, let others deal with it. But we know we can do better for our families, and it starts today. You've worked hard, maybe saved some money, bought a house, made some investments. All of these are valuable assets. And today we'll talk about the importance of preparing the documentation for the distribution of these assets after death. You will learn about estate planning, wills, trusts, probate matters, and more. And to help us through the conversation, it is my pleasure to welcome our speaker, Daniela Hernandez. She's an attorney who over the last year has focused her career on estate planning and probate matters, including trust and will contests, contested conservatorship proceedings, and trust administration. She is passionate about empowering underrepresented communities and aspires to help our familias transfer generational wealth. Bienvenida, Daniela. Can you please tell us a little bit more about your work and anything specific to estate planning? Saludos, Daniela.
Hola, Patricia. Thank you so much. And thank you everyone for joining us. Thank you, Patricia, for the invitation to have this conversation that is very important and that, like you said, can be put off, but is something that we want to encourage folks to do sooner rather than later. So just a little bit more about me. I currently work for a law firm that specializes in estate planning, post-death administration, and representing individuals such as trustees and beneficiaries in probate litigation. And while I assist with a little bit of everything, by far my favorite aspect of my work is estate planning. I enjoy getting to know our clients and drafting estate plans that are specifically tailored to their financial and familial situation and stage of life. Whether, for example, it's a married couple or a single parent with minor children, or couples in their later stages of life who have grandchildren that they want to be able to transfer their wealth to. So understanding what our clients' goals are, however straightforward or complex they may be, and advising and assisting with creating a comprehensive plan to achieve those goals is something that I have really enjoyed doing.
That is wonderful. Thank you. I mean, these are such important topics, and happy that you're, here to help us through it. But to start, I know people are coming in, all the time. Just for those of you who have just joined us, I'm Patricia Perez, and I'm AARP California State President Emeritus. And joining us is attorney Daniela Hernandez. but we'll start first the conversation with a poll. Daniela, to help you, know who's watching us, I want to ask the audience, participating, and so you get to know our guests, a yes or no question. I just want to know, I currently have a will in place. I just want to, let's see, I want to run the poll. So we're having a little bit. Oh, so people are responding yes, yes. Some people no. Okay, good. So some people are responding, oh, a trust, good. So, we have quite a number of people who don't have a will, but perfect. It's good to see such a number of people responding. Oh, here it is. Well, let's see, here's the responses. I currently have a will in place. I guess let's take that also as a trust, right? It could be a trust or a will, or yeah, please.
Yeah.
Yeah, a trust
Okay.
or a will, if you have any kind of arrangements. Right now, we're kind of 50-50.
Okay.
Yeah, yep. Yeah, seriously.
Wow.
All right, I'm going to stop sharing. All right. And share results. All right. Yeah. So we have 50-50 people.
Okay.
All right.
Wow. Thank you for doing that. That definitely helps sort of know where people are at. So maybe for some of you who already have a trust in place or have something in place, this might not be new information, but I do hope that there are other things throughout this presentation that will be new information. So I'm going to go ahead and start sharing my screen in just 1 second here. Okay, I'm going to pull up my presentation here. Okay, can everybody see that? Oh, we're starting on the last one. Okay, so, all right. So I think the first thing we want to just go over is some of the basic steps to create a will. And so for those who don't know, the same way that we have a criminal code section in California, there's also a whole code section dedicated to probate matters. So wills and trusts. So for anybody who's interested in reading that code, it's on here, the California Probate Code section 6110. But basically, the elements of a will. So in order to create a valid will in California, it needs to be in writing. It needs to be signed by the testator. And who is the testator? The person whose will it is. So if I am trying to create a will for myself, I am the testator. Me as a testator have to have the intent that this document is my will and that I understand what that means. The will also needs to be witnessed by 2 individuals. Those 2 people must be present at the time that the testator signs the will. The witnesses must also understand that the document that the testator is signing is their will. On here, I have disinterested witnesses. And what that means is the witnesses that you have for your will, you want them to be people who are not going to be beneficiaries to your will. They're not going to be receiving a gift from your estate. And that's just to help avoid, people saying like, oh, well, sister who is getting the entire estate was one of the witnesses. Maybe there was some undue influence there, right? So just to kind of prevent some of those things, you want the 2 witnesses to be people who are not receiving anything in that will. So those are overview, general elements of just a will.
And Daniela, what is the difference between a will and a living trust? I know some people said that they have a trust. What is the difference between the two?
Yes, absolutely. So with that, let me put here, so will versus a trust. So both a will and a trust are documents that where you lay out who you want to receive what, right? So what assets do you have, and whom would you like to receive those assets? So here on the left-hand side, we see a will. So a will allow you to nominate what's called an executor. And that executor, once you pass, the executor will follow the directions that you have laid out in your will that say who is going to get what. However, a will does not avoid probate. And if there's anything that you take from this, it's we want to avoid probate, because probate is a costly and lengthy court procedure. And yeah, we just want to avoid probate to the extent possible. A will also does not keep the administration private. As you can see here, a will must be filed with the county within 30 days of someone's passing. So that will that you write is going to become public information. So anybody who wants to look at your will is able to do so, because once you file that will with the court, it's going to become public information. And a will, you can amend and revoke it. So, you know, if the will that any of you have was drafted 10 years ago, and, you know, this is something I will remind folks throughout, is that wills, whether you have a will or a trust or any other estate planning documents, you want to make sure that they're up to date, that you revisit them every year or so, or whenever there's a big life event, because you want to make sure that those wishes that you wrote in that document, whether a will or a trust, remain the same and they haven't changed. So thankfully, with a will and a trust, you can amend and revoke. So once more, a will merely tells a judge and others who you want to receive your assets, but your private matters become public information. Now with a trust, in the same way, you're able to, sorry about that, you're able to nominate a successor trustee. So that is who is going to take over your assets after you've passed. And again, be able to provide instructions regarding the disposition of your estate. However, unlike a will, a trust does avoid probate. And again, that's the goal. We want to avoid probate. So in that sense, a trust does offer a little more, you know, it's not going to be as costly. You're not going to have to go to court, unless, of course, a family member wants to contest the trust, but we won't get into that just yet. And again, with a trust, you can also amend or revoke it if it is a revocable trust. There are sort of two kinds of trusts. There's a revocable trust, so you can make changes to it, and an irrevocable trust. You cannot make changes to that. So with a revocable trust, you may make those changes. I do want to provide a little more information about what a trust is, because it is a little more involved. So we'd like to think of the trust. So a trust document is like a contract that you have with yourself. So you are the trustee. You are the trustee and the trustor. And on the next slide, I think I have some terms so that we can keep in mind what these terms are and what they mean. So as the trustor, you still own your assets, but it's through the trust. So, you know, let's say, for example, you create a trust and you have a property, you have your home. What we'll do is we will create a trust transfer deed that transfers your name on the deed, and it's gonna change to now the name of your trust. So it's technically gonna be your trust that owns your home, but that is what protects your assets. So again, you still remain in control of your assets, and you know, are able to manage everything while you're alive. But once you pass, your successor trustee is then the person who takes over, you know, after you die, or if you become incapacitated, and then they will continue to manage your assets as you indicate in your trust. So I know that was a lot, but you know, we'll continue to talk about it.
But Daniela, can somebody, you know, we can decide whether we want a will or a trust, or should we seek professional advice?
Yes, absolutely. So again, I think in terms of avoiding probate, which, you know, and I should have put a slide with what
Like,
the
no
fees are
probate.
like. Yeah, yeah. You know, the fees are pretty high in terms of, so, you know, the court is going to take a percentage of the gross value of all of your assets. And so, you know, it depending how big that number is, it's going to increase. So, and there's also just, you know, other attorney's fees and just court fees. So it's costly and it takes a long time. I think it's at least more than a year. And so what happens is, you know, with a will, yes, you are letting the court know who is going to receive what, but this is a process that takes a really long time, and nothing can be distributed until the court, or excuse me, until the judge orders for things to be distributed, and that can take, like I said, over a year. So, you know, for that reason alone, you know, I think trusts are preferable. I do think that a will is better than nothing. You know, because if you do not have a will, you do not have a trust, and you die without that, the court then is going to, you know, assign the distribution of your assets according to California law. And that may not be what you want, right? So it's always going to go to your spouse first. If your spouse is not alive, then it's going to go to your kids. If your kids aren't alive, then it goes back up to your parents. So it's, you know, it's law. And so if you do not have a will where you yourself get to state who you want to get what, then it's just gonna, you know, fall to the default. So a will is better than nothing. But for many reasons, which we will continue to go over, I think a trust does provide a lot more flexibility with your wishes. And yeah.
Yeah. There's been a number of questions. Oh, please, if you have any questions, put them on the chat, or if you're watching through Facebook, put them on the comments. Please, we want to get to your questions. Daniela, oh, and if you just joined us, I'm Patricia Perez. I'm AARP California State President Emeritus, and we have estate planning professional attorney, Daniela Hernandez. So thank you so much for joining us. Daniela, we've had a number of questions regarding the cost, the difference between a will and a trust. I assume that a trust is more expensive, you know, to execute, but I don't know. I mean, some people think like it's really costly. Do you have any idea?
Sure. Yeah. So, so I would say it definitely depends. So, you know, for example, some law firms, and this is another slide we'll get to too, is that usually when you go to an estate planning attorney's office, we're not just going to say, you know, here, you only want a will, here's a will, unless that's specifically only what you want. And the reason for that is because there are so many important documents that can benefit people. And so to create a comprehensive estate plan, there are various documents involved. And so that will increase the cost. So, you know, I would say that a comprehensive estate plan with, you know, let's see if I can get to that slide now, actually. So other important estate plan documents, so a trust, a pour over will, a will, power of attorney, advanced healthcare directives, all of these things. This is more of a comprehensive estate plan. So when you get something with all of these things included, it is going to be a few $1,000s. That's more of what I've been working on. So I haven't seen, usually I would say, you know, if all you need is just a will, you just want something in place because, you know, maybe you're going to go travel and you just want some peace of mind that you have something written down. You know, maybe attorneys will just charge you on an hourly basis, however long it takes them to just draft that one document. And maybe that way it'll be a little cheaper. But, you know, again, these are very important documents that we can go in depth. But yeah, so if a more comprehensive plan will be more expensive. So a few thousand, you know, I don't know, anyway, depending, right? Maybe starting at like 3,000 and up. And it also changes whether you're an individual or if you're married and you want a joint trust. You know, that might be a difference of maybe like $500 or so yeah, so I would say, you know, a few $1,000s.
Perfect. But like you said, a will is better than nothing, right? So at least start with that. And then if you can, a trust is better. It gives you the flexibility, a lot of control. So
Yes.
it's, you know, good place to start. But you're talking about estate planning. That would be a you know, a good question, you know, poll. I'd like to know people who are interested in an estate plan. I'd like to conduct a poll question. And the question would be, I'm interested in creating an estate plan, but do not know where to start. And let's see, hopefully, let me see. There we go. I'm interested in creating an estate plan. And you see it right here on the screen, what some of the estate plan documents are. But maybe for some of us, we may not even know what some of these documents, you know, are, or how complicated it would be to obtain.
Right. Mm-hmm. Yes,
Well,
and we can.
Good. It seems like overwhelmingly people want to do something. They do want an estate plan.
Mm-hmm.
So we want to do something. We just, you know, either don't know where to start or
Right.
or just maybe have
And that's-
problems starting.
Yeah, and that's completely understandable. Completely understandable. I think if, you know, without this information, or you don't know what you don't know, right? So it makes absolute sense. And I hope that after this, there will be some more clarity with this.
Oh, perfect. And then, you know, how would people go about, what do we need? A financial planner, an attorney? What would be the first step for people?
Yeah,
You know,
so
what would they need to do?
yeah, so I would say from my experience, certain individuals may not necessarily need a financial advisor. You know, if they have more of a modest estate. On the other hand, you know, very high net worth individuals where, you know, there are more tax implications. I think in that case, then it would be a good idea to consult other specialists. So, you know, tax professionals and other financial advisors. So it would depend on each person's situation. Patricia, if it would be okay, if we are doing okay on time, I'd like to go over some of these specific documents and
Absolutely.
what they are.
Yes, please go ahead. And then we have a number of questions. Sorry, before you do that, if you have any questions, please add them to the chat or the comments if you're watching through Facebook. Also, I know some people are still entering the conversation. This is being recorded, so even if you missed any of the presentation, you can view the recording later at aarp.org/Let's Talk Dinero. Sorry, Daniela, please go ahead.
Okay, thank you, Patricia. So on here is a trust, as we've briefly gone over. And so these estate plan documents are, again, part of that comprehensive estate plan. So usually when you have a trust done, there will also be a will, and there will also be a pour over will. Now, a pour over will is sort of a backup document that will allow any assets held by you, which were not previously transferred into your trust, to be added to the trust at the time of your death. Now, sometimes certain things may be subject to probate administration, but usually it's kind of like a catch-all. And so again, going back a little bit to the trust. So your trust is sort of now the owner of your assets, right? So once you have a trust created, and every attorney will tell you this, the most important thing is to make sure that you retitle your assets. So, you know, we create documents, we create letters. For example, people who have bank accounts, right? We will create a letter that our clients can then take to their banking institution that says, please change the name, the owner name of all of my bank accounts to the name of my trust. So now all of your assets are under the name of your trust, and that's how they are protected. So that is one of the most important things that you have to do once you have created a trust, is to retitle everything. Otherwise, what's the point? The trust is kind of like a bucket. And so you have to put all of your assets in that bucket to protect them. So that's kind of how that pour over will comes into play. So let's say, you know, you created a will, or excuse me, a trust 5 years ago. Everything at that time you retitled to the name of your trust, but you just bought a new property, you forgot to put that property into, or you forgot to retitle that property to the name of your trust. So a pour over will helps with that. Although, again, it does, there are certain things that are still subject to probate administration depending on the value. So, you know, it will depend on that. But again, that's sort of what the pour over will does. It's more of like a backup. So something else important with a will, and this is for people with children who are minors, there's usually a nomination of guardian included as a part of the will. So again, if you have minor children, through your will, you're able to nominate people who will serve as the guardian for your minor children. Power of attorney. This document gives another person the power to deal with legal matters, any trust and non-trust assets that you may have. There are a number of powers that you may give to this person that you assign, that you nominate. And it's up to you to decide which powers you would like to give to that person or not. So that's something that you can discuss with your estate planning attorney. You know, how much power do you want to give them? There are broad powers, you know, such as them having the power to sell and transfer all of your property. So yes, definitely want to make sure that you select the different powers that you want. Now, this is important. So there are two options usually with powers of attorney and advanced healthcare directives. This power that you're giving to someone is going to be effective either at the time of your incapacitation or immediately, as soon as you sign that document. And so that is up to you. And again, a conversation to have with your estate planning attorney to decide when would that be the most beneficial for you, depending on, you know, everything else that you have going on. So again, it's either the power of attorney that gives someone else the power to, you know, make legal decisions or transactions on your behalf, that either will become effective immediately or it will become effective until you are no longer able to do that for yourself.
Yeah. Daniela, sorry, quick question. If somebody has a durable power of attorney, do they still need a trust?
Well, so a power of attorney, and it depends on what powers you have given to someone, right? And so if that power of attorney only lets someone do, you know, two small things, then it's not going to help. It's not going to help you in terms of transferring your assets, right? These are two very different things. Power of attorney, again, just allows someone else to conduct transactions on your behalf. But a trust, again, this is, you specifically write out all of your wishes. Who do you want to have what? There's so many, like I said, just like, so you have so much flexibility with the trust, because let's say, for example, you have three kids, and you want to leave all of your assets to those three kids. However, one of them may have a drug addiction problem, and you want to be able to provide for that child. But if you're going to leave them, $10,000, $20,000, however much, and you're concerned about, well, what's going to happen with, what are they going to do with that money as soon as they get it? I want to know that the money I'm leaving for them is going to be used for certain purposes. So in a trust, you can detail that. You can say, I want this money to be used for these purposes. Again, another issue that may come up is maybe you have another child who has special needs, and you want to make sure, again, that the money that they're receiving are going to be used for certain purposes. I'm trying to think of other, very specific things that you can do with the trust. It's just having a conversation with an estate planning attorney about, things goals that you have, and that estate planning attorney can then help guide you to find the best ways to include all of that in your trust. So, long answer to your question, they're very, a trust and a power of attorney are completely different things. Yes, the trust has to do with transferring your assets. Power of attorney, you're just allowing someone else to conduct legal transactions on your behalf.
All right, thank you. I know we still have people coming in. Thank you so much for joining us. We are speaking with the state planning attorney, Daniela Hernandez, and Patricia Perez, ARP California State President Emeritus. We are recording this, so no matter what you've missed up to now, you can view it later on arp.org/Let's Talk Dinero. Daniela, question: do we need to have both a will and a trust, or it's one or the other?
Yeah, so usually with the estate plans that I have worked on, again, comprehensive, so we always just include both. And again, if you are traveling, or you just want something in place right now, you know that maybe you can't afford a trust at this moment, but you want something, again, a will is better than nothing, but a trust is more of what protects your assets. And the will under the trust, again, is just more for other things, like if you were going to include a nomination of guardian, that would be included there.
All right. Perfect. Question: if you have a trust and you already put, whatever you have, some assets, but then you acquire more that you do not include in the trust, what happens to those assets?
Yes. So depending on, so you do not put those assets into your trust, and then you pass. If you have a pour over will, the pour over will is going to help. The pour over will is saying that it is your intent that all of your assets be a part of your trust. So if you have a pour over will and there aren't any restrictions regarding the value of that asset, because in California, and I'm trying to remember the exact number, I want to say it's like $166,000 worth of assets do not need to go through probate. But if it's over that amount, then they do have to go through probate. So if the amount of those assets that you did not put into your trust, if that amount is over, I think it's 166 some $1,000, then it will have to go through probate. But otherwise, you should be okay. You will still have to go to the court and submit a filing that says, I didn't include these things in my trust, but it was my intent to do so. And then the court will just approve it. But, so you don't have to go through the whole process, but it is still something that you do still have to file.
Okay. You tell us that there's lots of flexibility in the trust. Can you have just one successor trustee, or is there
Yeah,
flexibility there
yes.
too?
Yes, good question. Thank you. All of these have been great questions. So in a trust, so let's say, for example, we have a married couple. So both are technically the trustees, or the trustees and the trustors during their lifetime. So when one of the spouses dies, the surviving spouse is now the trustee of that trust, assuming that they still have capacity to do so. After that surviving spouse dies, then that's when the successor trustee is the person in charge. And so during the estate planning process with your estate planning attorney, you will be asked to name successor trustees. We always encourage, people to have alternates. Usually we have at least 3. And the reason for that is because you just never know what's going to happen. Let's say, I create a trust and I name my successor trustee as, my sister. But what happens if my sister dies before me? And that's the only person that I have on my trust, then we have a problem, right? Because I've said, I designate this person to take over, all of my assets, but she's no longer around. So we always want to have alternates. And yes, sometimes, clients are like, oh, well, but, it's my son. My son isn't going to die before me, but you don't know that. So yes, definitely want to have alternates.
All right. We have questions regarding specifics, like what's the difference between a trust and a living trust?
Yeah, so a living trust is just a kind of trust. I would say the 2 big differences are a revocable trust and an irrevocable trust again. So a revocable trust, you can make changes to it. You can make as many changes as you want to it. And again, we encourage people, we encourage our clients who already have a trust or a will or any of these other documents on here on the screen, that you review them regularly to make sure that the people who you assign the distributions that you want to be made of your estate continue to be true. Otherwise, you're going to want to update that. So again, yes, a living trust is just a kind of trust. There is no, I feel like we're actually trying to shy away from the living trust now. It's just revocable trust or irrevocable trust.
And like you said, irrevocable trust, you cannot make changes once it's in place.
Correct.
You don't own the trust anymore, correct? Or
yeah, you're just saying, this is sort of like my last and final word. Nothing is going to change. With a revocable trust, you are there. There is a clause in the trust that says I can amend this trust at any point while I'm alive, as long as, it's something in writing and signed by the trustees or the trustors.
okay. There's a question that came in. It says all personal financial accounts have a beneficiary and the person does not own any real estate. Is a will okay, or is a trust needed?
So no real estate. Yeah, I mean, I think that, this is only some of the information, right? We only know
Yes,
these
right,
two
right, right.
things. And, so there can be lots of other reasons why you may want a trust, or you may prefer a will over nothing. So I think that question should be discussed with an estate planning attorney, because when you sit with us, with any good estate planning attorney, we are going to ask many questions. And it's important for you to feel comfortable with your estate planning attorney, because, again, we go into these questions of like, well, are you concerned about any of your children? Do are your children all in good places? Or, the issue with the child who has, drug issues. And so, this is where an estate planning attorney comes into play, to ask all of these questions that we already know to ask, because we know, we've seen other examples of estate plans. So, we try to help people create the most individual and tailored plan that we can.
And Daniela, now with the availability of online documents like trusts and wills, can we trust those? Are they reliable, or we should avoid those?
Yeah, so I mean, with some of those, the pros to those, I think, are that they're less expensive. But that saying, you're going to get what you pay for. I've never worked with, some of those like LegalZoom or, these other sort of platforms that create legal documents for you. There's nothing like sitting down with someone who has studied the law, who has been practicing in this area, who knows what follow-up questions to ask you. If you're just, clicking things online, you don't get those sort of follow-up questions, right? Or you don't get to ask some of those questions. So, I think if you're comfortable with just, clicking things and, not knowing sort of other things that may be in play, then, I'm not going to say don't do that. I just do think, though, that it is beneficial to have that conversation with someone who knows the law.
And it's so important, just go to trusted sources. If you are going to be providing any of your confidential personal information, please just make sure you have vetted them, you know exactly what you're doing. Just go with open eyes. Like Daniela said, if this is very important. So if you can go with a person that or you can interview directly, please do so. Just online, just be very careful with that. Okay.
Yes.
All right. We have a question with a trust. The designated trustee, would they have full access once to the money, resources, your bank accounts, everything, if the person who wrote the trust is incapacitated? So they have full run of your trust, the trustee?
Yes. So that is something that, right. So in your trust, you have, during your lifetime, if it's just your trust, you are the trustee during your lifetime, unless you become incapacitated. And then at that time, your successor trustee will then take over. So this is where it's important to, in your selection of successor trustees, right? It needs to be people who you trust. For example, you're not gonna name your brother who is horrible with money, and you just don't know where he is half the time. Like, that's not the person you're gonna want to nominate for these, or appoint to these positions, important positions. So, nope, sorry about that.
Yeah. So really be careful in terms of who you allow to manage your assets.
Yes,
You've worked hard. These are your assets. So yeah, who do you appoint?
Exactly. And sorry, Patricia, just,
Yeah.
that's another, important conversation to have with yourself, with the person who you are considering to appoint, because you also don't want to just appoint one of your children and then they have no idea that they're going to be your trustee until you pass away. And they're like, oh, I have to do all of this now. Like, maybe it's something that they don't want to have to deal with. So definitely need to have those conversations with the people who you plan to appoint to these positions. And if I may really quickly, Patricia, I did want to just cover these last 3 documents on here on the
Oh,
screen.
yes, sorry. Go ahead.
Oh, that's okay. I know there's so many questions
Yes.
and, I'm glad we're able to go over them. So I last left off on the Advanced Healthcare Directive. And so this document, like a power of attorney, assigns an agent to make decisions on your behalf, but in this case, it's medical decisions. And so that will allow them to sign consent forms or releases with hospitals, doctors. It also acts as your, as your way to indicate what your end of life decisions are. So for example, if you're in an irreversible coma, or you're in a persistent vegetative state, just terminally ill, and the use of life-sustaining procedures are only going to artificially delay your death. If you're in that kind of situation, and hopefully not, but if you ever are, in your advanced healthcare directive, you can state whether you do want that, life-sustaining treatment or not. Or you can say, I don't want to be on life support, whatever happens, happens. And you're making that decision. You're not putting it on your family members to make that decision, or a doctor who doesn't know what your wishes are. So that's something that's really important to have in place. There are also other kinds of instructions or wishes regarding your personal care that you can include in an advanced healthcare directive. And I'll just quickly give an example. Like we had a client who said, I do not want to be placed in a nursing home. Like, no matter how much, medical care I need, I do not want to be placed in a nursing home. I want to be provided 24/7, at-home care if I ever need it. Like that was their, that was their wish, is I want to use all the money I have. Like you said, you've worked hard for your money. If you don't want to be placed in a nursing home, you want to stay comfortably at your house and have, others come to you and assist you, then that's your wish. And that's, that's what you'll get, to the extent that there's the money for that as well. So, like I said, the same way with the trust, with a lot of these documents, you can be very specific with your wishes. So that's Advanced Healthcare Directive. And then really quickly, HIPAA authorization and waiver, the release form, that just authorizes your healthcare provider to release information regarding your otherwise confidential medical information to your agents that you have appointed as your Advanced Healthcare Directive agents, and any other people that you want. So that's another important document to have. And then last but not least, final disposition instructions. That's just regarding whether you want to be buried or cremated, what should be done with your ashes, where you wish to be buried. If you already made arrangements somewhere, include that information. Again, it's just making the decisions for yourself, so you don't leave it to other people to, to have to decide that during a really difficult time already after you've passed. So
yeah. No, absolutely. And many times, we think like, oh, our children get along so well. Nothing like, having to have these terrible discussions after we're gone to, tear families apart. So please, if you can, take care of it. Daniela, question. If you give somebody the power of attorney and then you change your mind, want to choose somebody else, you can do that, correct? So
that's correct. Yes,
yeah.
Absolutely.
So you're not like,
right,
obligated to use it. Perfect. We have a question. what about people who own property in two different states? Like where should they, their will or their trust or?
Yeah, so every state has their own like probate code, has their own laws about what happens when someone dies and they don't have a will, or they have a will and what happens. So I would recommend for folks who do have properties in other states to probably consult an estate planning attorney in that state, because the laws are different in every state. So you want to make sure that you're getting the correct information for the property or assets that you have in that state. Otherwise, you could be looking at two different probates in two different places, and that could get messy.
Perfect. Daniela, I know we're bombarding you with questions, but we so appreciate a question. If you do a trust, a couple does a trust, and then the couple separates, who owns the trust or the will, or what would happen then?
Yes. So if you have a joint trust and then the couple has to separate or divorce, at that point there are just different steps that you're going to have to take, lots of considerations to make, especially if there is a divorce proceeding and assets need to be divided a certain way. So with that, I think it'd be a good thing to talk to someone who can know your specific situation, whether there's already been some judgment, divorce judgment, or not. I think it depends on a few things.
Okay. Another question, can the trustee and the primary beneficiary be the same person in a trust?
Yes, good question. Yes, a beneficiary to a trust may be a successor trustee. So for example, if if I'm creating a trust and I know that I only have one daughter, she's going to be my only beneficiary, I can name her as my successor trustee because she's the only person I trust, et cetera, et cetera. That's not an issue.
Okay. Daniela, do you have additional slides that you want to go through? I know you want to get through these documents, but please share.
Yes, just this one more that I think these are things that you can do right now. The search for an estate planning attorney can be something daunting as well, and can take a while. Again, you want to work with someone who you feel comfortable with, because you need to help us help you, right? You need to be open about your situation, about if there are family members that you have concerns about, or in your own couple that you have concerns about. You want to feel comfortable with your estate planning attorney to share these things so that we can better advise you on what to include in your documents. So again, that's a whole process, but these are things that you can do right now. So again, the Advanced Healthcare Directive, there are certain medical providers that already have these documents, in a PDF form, and you just have to fill it in. So for example, with Kaiser, all I had to do was just Google Kaiser Permanente Advanced Healthcare Directive, and it popped up right away. And they have it in different languages. So, that's something that people can do. An Advanced Healthcare Directive is just so important. So that's something that you can do right away. You don't need to pay for it. Especially if your medical provider has it on their website. You would just need to make sure to keep your original that you sign. It does need to be witnessed by two people or notarized. But as soon as you have finalized that with the witness signatures or the notary, keep the original, submit a copy to your medical provider, keep a copy in your car, God forbid there's a car accident, someone can look through your glove compartment, find that document, they kind of know what things to do, and obviously share copies with your healthcare agents that you have appointed. So that's one thing that people can do now. Another thing is, people have retirement accounts, life insurance, brokerage accounts, a lot of these have beneficiary designation. So when you create your account, it asks you to say, you know, if I pass, who do I want, you know, these funds or these assets to go to? And you know, you can do that right then and there, and that doesn't have to go through probate. That doesn't have to. These are things that are just kind of transfer on death. So you know, again, with the whole updating and revising, making sure that these things are up to date. We had a client who had life insurance. He had named his mother as the beneficiary, and she had passed like 10 years ago. And so, you know, these are things we want to just make sure that you update.
Yeah. Daniela, do you have a slide with your contact information? Or if not, would you mind including it in the chat just
Sure.
in
Of
case
course.
people
So
want to contact you directly?
yes. So I can put in the phone number to my law firm's office. It's not my personal law firm, but is where I work. And we can offer an initial consultation. So then at that point, if folks just have more questions following up with this presentation, I can offer that. And then, you know, if we want to move forward, then we can establish an actual, you know, attorney-client relationship. But I can go ahead and put that in the chat, and yeah, I'll let you finish up while I do
Yeah,
that.
no, thank you, please. And just a reminder, you know, we had people joining us, you know, throughout. This is being recorded and it will be available. It's going to be emailed to everybody who registered. Otherwise, you can go to aarp.org/let's talk dinero, and it'll be available, I think, you know, in a few days or so. We also have videos of other conversations we've had, other sessions on managing debt, you know, buying a house. I mean, just different topics. So it's all really just to help people with their financial planning, financial security. And, you know, with this one, of course, estate planning is such an important topic. Daniela, at what age should people start really thinking about having a will or a trust?
Yeah, sure. So I would say, you know, again, depending on many different things, like you may be on the younger side, but you have children who are minors, you know, so at that point you would want to definitely consider a will or a trust. If you own property, if you're a business owner, yeah, just lots of different reasons why you would want to do that. You know, I think once you're, you know, you have a family, you have property, I think that's when it probably becomes more applicable to people. So I don't know if I can say a specific age, but you know, just certain things considered, your family, what assets you have, and you just wanting to be able to have that peace of mind that your assets are going to be protected.
So I guess you nailed their peace of mind, no matter what age. If you just want peace of mind,
Yeah.
knowing that those you love will be protected, just, you know, do it. And please, you know, don't, you know, put it off. If you're thinking about it, if you joined us today, that's a first step to getting it done. Daniela, any wrap up thoughts, any, you know, final tips?
Yeah.
Final comments?
Yeah, I mean, you know, there's just so much regarding estate planning that, you know, we obviously couldn't cover everything. So by no means, I don't want, you know, anyone to think this is all the information you need. I really tried to give like an overview. So, you know, please, AARP is providing resources where you can continue to do more research. You know, YouTube, like Google stuff, like just to kind of get a better idea of things. And then once you feel ready to take that step to meet with an estate planning attorney, please do so, because again, there is no way we could have covered everything right now. So, you know, just keep that in mind. And again, we want to avoid probate. But yeah, those
Yeah,
are some of my
key takeaway, avoid probate. Yeah.
Yes.
Yeah, so plan ahead, right? And Daniela mentioned that ARP has quite a bit of financial resources and information available at aarp.org/retirement planning. I mean, it's a great place just to start your research once again. aarp.org/retirement planning. So please, just a good place to just start, your research. I know that there were so many questions we couldn't get to today. We appreciate everybody for being here. We certainly will be covering more on this topic. So, there's more to come. Daniela, I want to thank you very much for joining us today on our series, Let's Talk Dinero. We will be continuing to collaborate with financial experts across the state to talk about retirement planning and more. Join us in December for our next and final event of the year. And of course, you can visit, I know I've mentioned it enough, aarp.org/Let's Talk Dinero to view our previous event recordings and a list of the upcoming events as well. So I hope to see you next month. Daniela, muchísimas gracias. Thank you for
Gracias
joining
a
us.
ti, Patricia.
And thank you so much for sharing your expertise with us. We have come to the end of the session today. I hope you have found this information helpful and that we will see you next month. Hasta
Thank
luego.
you, everyone. Happy holidays.